Welcome to Divorced from Reality with Johnny Bardine.
Welcome to Divorce from Reality with Johnny Bardine. Johnny is a dedicated attorney who has been serving the Tampa Bay community for over a decade with a mission to help individuals and families through their most challenging times. Johnny provides compassionate, fierce advocacy in all marital and family law matters. I'm Lisa Mosbey, and in today's episode, we're talking about temporary orders in a Florida divorce and what the court can decide before your case is final. Welcome back, Johnny. Thanks so much for joining me for this conversation.
Thanks so much. I hope you're well.
I am well. It's tough talking about divorce, but statistically, many of us will be affected by it. So once a divorce is filed in Florida, what exactly is a temporary order and why does it exist?
Divorces and other family and law matters can last a long time, right? So from the time that you file to the time of final judgment could be an unpredictable course, and we don't know how long it's going to take. So a temporary order is an interim relief that the court can enter while that action is pending. And the reason they exist is purely practical. That it could take months to well over a year to get your case done, and sometimes considerably longer when there's a parenting issue or a big things to decide with a business valuation or alimony or splitting up assets and liabilities. So life doesn't pause. Bills come due, kids need a schedule, someone has to be somewhere, and the mortgage company doesn't care that you and your spouse haven't agreed on who's writing that check. And so the authority for temporary orders comes from Florida statute, and the courts have broad discretion over that. And the thrust of it is that these cases are going on for a long time. They're very complicated sometimes, and the courts are going to do the best they can to make sure that no one is steamrolled through that process.
And Johnny, you mentioned many temporary orders situations where they would apply. The one I want to focus in on is if one spouse needs financial support right away, how does temporary alimony or temporary child support work in Florida?
Well, temporary alimony also comes out of the statute 61.071, and the analysis is the same two-part test that you see at the final judgment, which is the court will weigh one party's need versus the other party's ability to pay. So the courts will look at the financial affidavits, which will have been filed by that point, the standard of living during the marriage, and whatever evidence the parties present about expenses and income. So after the alimony reform bill from a couple years ago, permanent alimony is gone, which is the type of alimony that a lot of people traditionally think about, where someone writes a check every month until the other person gets married again or dies. So what the court is thinking about with alimony now is that all that alimony is going to be temporary in some way, and so the ability for the court to order temporary alimony was unaffected by that statute change. Similarly, temporary child support is a guidelines calculation, just like it is in the final judgment. So you take the income of both parents, plug in the overnight schedule, factor in some of the offsets, which are childcare and healthcare costs, and it spits out the child support number, just like it would at the end of the divorce, only this is happening earlier in the process so that people can sort of adjust and survive the process of the dissolution.
And you mentioned child support, but what about child time sharing when there's children involved? How do schedules get put into place? Are those final decisions or are they temporary as well?
They are decided either by agreement, which is preferable, or by contested temporary hearing. But happens before you get to a contested hearing on the parenting issue in the final hearing. So you're almost always going to be required to go to mediation first. So I think one important thing to remember, and probably the most important thing to take away from this episode, is that even though these are temporary orders and sometimes the need is exigent or urgent, the court is unlikely to take any action until mediation occurs first, to give the opportunity for the parties to agree. So they won't even schedule or hear a temporary relief order until after mediation happens, and that can be 3 or 4 months after the action is filed. You don't just get to skip it because you want to. And communications during the mediation can go are confidential and generally not admissible, but it gives the opportunity for the parties to agree on it prior to the court deciding. And if the court has to decide, then the temporary relief hearing on time sharing is a lot like the one on the final judgment, where you have to look at the best interest of the child and the factors in that statute weighed against what is now the statutory presumption that each party is going to have equal time sharing.
The other thing that I'm thinking about is the house. Where's everybody going to live? Can a court grant one spouse temporary exclusive use of the marital home? And under what circumstances does that usually happen?
Yeah, it happens routinely, and it happens in almost every case in which the parties own a house together, and one of them is going to vacate the house during the pendency of that action. That also comes from statute, and the court is looking primarily at the best interest of the children if they're in there, and the financial circumstances of the parties, and whether there's any history of domestic violence. And when kids are involved, exclusive use typically follows the majority time-sharing parents. The parents stay, so that the children stay in the home and maintain stability, so they go to the same school, same neighborhood, have their same rooms. And so those are the considerations the court is going to look at when deciding one party getting exclusive use and enjoyment of that home.
We've got a little specific on a couple of these, but generally speaking, what does someone have to show the court in order to obtain a temporary order? Is there specific evidentiary standard that applies to these situations?
The standard in the law, to sound like a lawyer for a second, is the preponderance of the evidence, which means that it is more likely than not. Mechanically, you need a verified motion, a current financial affidavit, exchanging the financial disclosure, and whatever other supporting evidence fits that relief: bank statements, payroll records, communications between the parties, photos of the home, whatever. So for temporary support, the court wants to see income and expenses laid out clearly, and a sloppy or incomplete financial affidavit hurts your credibility for the rest of the case, sometimes permanently. So getting it right at the temporary relief stage really sets the table for your relief that you can expect in the final judgment.
And you'd mentioned we have to go through mediation. Is you said that could take a little bit of time. How quickly, if it needed to be urgent, how quickly can a temporary hearing typically be scheduled in Florida? And does timing vary depending on the county?
So, right. So in this case, in these cases, this is one of the most challenging aspects I have with regard to managing client expectations. And in fact, I don't particularly understand it myself. But the speed at which you get to a temporary hearing can vary considerably depending on the circuit you're in or the judge within the circuit. And in where I have had in Pinellas County and in Hillsborough County, you're typically looking at about 90 days from the motion to hearing on a non-emergency temporary. But that's assuming you've already cleared the mediation pipeline that we talked about earlier. So most circuits in Florida are going to require that the parties go to a mediation conference to try to resolve it before even resolving the temporary issue or setting it for hearing. So I guess the takeaway from that is that I think it's important to sort of be prompt about the financial disclosure and filing that motion and scheduling mediation, so that although it's going to take longer than you want, it won't take as long as it could.
And patience, because all of these things do get drawn out from time to time, don't they?
Mm.
Are temporary orders binding until the final judgment, or can they be modified during the case if circumstances change?
Right. They're binding and enforceable just like any other court order. Contempt is on the table if you willfully not. Contempt is on the table for noncompliance, and people do get sanctioned. But temporary orders are not immutable. A party can move to modify temporary order during the pendency of the case upon a showing of a changed circumstance, like a job loss or a child with serious medical need or a parent moving out of the area, things like that. A genuinely material change can justify revisiting the temporary order just like a final order in a dissolution case. But the final judgment, this is important to know, supersedes everything when it's entered. And from that point forward, you're operating under post-judgment modification standards. And the other thing worth mentioning is that temporary orders don't bind the court at final judgment. So just because you've got a certain relief in your temporary order does not mean that you can expect it at final judgment.
And then for someone considering filing it for divorce right now, if they're thinking about it, how can planning ahead impact the likelihood of obtaining a favorable temporary relief?
Enormously. The party who walks into a temporary hearing with a clean, accurate financial affidavit, organized documents, a realistic proposed parenting plan, and a coherent budget tends to win. So the party is scrambling, looks like they're scrambling, and judges know that. They see that. So before filing, you got to gather in your mandatory disclosure 3 years of tax returns, recent pay stubs, banks, credit card statements, retirement statements, life insurance policies, things like that. And so being organized at the front end is going to help you with that temporary hearing.
And Johnny, if both parties have attorneys, they need to compile that data and share it with both attorneys so that they can move forward. Is that correct?
Yeah, and even if they don't have attorneys, I mean, the general rule, the absolute rule is that under 12-285, the parties have to engage in mandatory disclosure in most cases. So they have to do the financial affidavit and then exchange the underlying documents that substantiate the financial affidavit. And that's going to become really the vehicle by which you can calculate what each party would be entitled to in a temporary relief hearing, and certainly with regard to the calculation of child support.
And I know one of your secret superpowers is amicable. You know, you try to keep these situations amicable between both parties. What final advice do you have for a couple who is making this decision right now? They're contemplating it. How should they best go forward to keep things amicable through the whole process?
Well, I can tell you that the way this year is starting out, that whatever superpowers I have are being tested to the maximum in terms of keeping matters amicable. But what you have to do is be clear with your client about expectations, about how long this could take, how much it would cost, what do you need to show to get the thing you want. And like I've said in almost every episode, the first person you talk to maybe shouldn't be me, right? It should be your partner, your co-parent, the person you're divorcing, because it's going to go much easier if you can agree than litigate endlessly.
Well said. Thank you so much for today.
Thank you so much for having me.
Folks, thank you for listening to Divorce from Reality with Johnny Bardine. For more information or to connect with Johnny, visit BardineLawFirm.com. Don't forget to like, subscribe, and leave a review if you found this episode helpful. And we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.